Thank you so much for joining, everybody. My name's Sarah Barclay. I'm the founder of the Medical Mediation Foundation, and we're really delighted to welcome Tor Butler-Cole and Jaime Lindsey as guest presenters for today's Conflict Cafe. I met Tor a long time ago when we were both doing our master's degree in medical law and ethics at King's, and I met Jaime in the last few years when she's leading, as she'll talk about later, a very interesting mediation research project. So just to give you the order of play, I'm going to hand over in a moment to Tor and to Jaime. We'll record until we get to the end of their presentation and then stop recording and open up for questions. It would be great if you can put your questions into the chat as they occur to you and as we're going along. So I'm going to start sharing the screen and hand over to Tor and Jaime.
Thanks, Sarah.
Thank you.
So, hi everyone, I'm Victoria Butler-Cole. I'm a barrister at Third and Essex Chambers in London, and I represent hospital trusts, but also family members and the official solicitor and children's guardian in medical treatment cases. But the first person you're going to hear from is Jaime, so I'm going to hand over to her to introduce herself.
Thanks, Tor. Hi, everyone. I'm Dr. Jaime Lindsey, and I'm an Associate Professor in Law at the University of Reading. I research and teach healthcare law, family law, and dispute resolution. And I'm also leading a research project which looks at mediation in healthcare disputes. So I may talk about that as well in a moment. So we can go on to the next slide. So I'm delighted to be here today to be speaking at this Conflict Cafe. I should say that Tor Butler-Cole KC is also a member of the advisory board for our research project, and Sarah Barclay is also a consultant to the project, and I'll talk a little bit more about that later. So today we hope to be able to leave you with a bit of an update about the lessons that you might be able to learn from recent cases in the courts about handling conflict in healthcare disputes between parents, family members, and patients. We are looking at cases usually where there's a best interest dispute, and we're also going to be looking at cases covering both adults and children, so quite a broad spectrum of types of disputes that we'll be looking at today. So I'm going to start. I'll say a little bit about the importance of involving parents, families, and patients in decision making. And I will then talk a little bit about the research on mediation before handing over to Tor, who will say a little bit more about what the courts have said about mediation and when to apply to court. So in terms of involving people in healthcare decision-making, there have been several cases in recent years, I think, where we can say the courts have taken a much stronger line on encouraging healthcare professionals to involve families and patients much more. And one of those cases is Gosh and MX on the slide, and I'll talk about that in a moment. But there are several others as well. So we have the Manchester and Verdun case. We have the Alderhay case, which I'll talk about on the next slide as well. And I think, of course, we know that most healthcare professionals are routinely involving families and parents and patients in their practice. But I think we just want to highlight some of the issues that the courts have picked up upon, and what you might be able to do to kind of avoid some judicial criticism if you do have a case such as this that does reach the courtroom. Also, just to say that the judicial perspective on involving families in decision-making really does reflect the underlying research, which indicates that people are kind of much more accepting of the decision if they have an opportunity to take part in it. And also, you know, the importance, as we know, of autonomy does suggest that patients and those around them should very much be involved throughout decision-making processes. So, as I said, I want to talk about the Gosh and MX case to start with. This is a really interesting case for several reasons, but I think it's one of the rare reported decisions which results in both a reported judgment, but also which talks about the use of a clinical ethics committee and mediation as part of the kind of litigation process. It's quite unusual for all three of those things to be present in a reported decision. So what was the case about? Well, it concerned a 9-year-old girl who had been born one of twins at 33 weeks. As an infant, she'd been diagnosed with a kidney function disorder, and she'd received a kidney transplant as well. At the time of the case, she was in the Gosh PICU for chronic kidney disease. So the case did reach proceedings in the High Court, but a short 3-week adjournment was permitted to allow for mediation to take place in the case. Now, as I said, there was also a clinical ethics committee process that had taken place in the case prior to the court proceedings. And I think if you read the judgment, it's really interesting how the judge is quite critical of that clinical ethics committee process, because the parents were not invited to attend it, they were not involved in it, and the judge really described this in the judgment as unacceptable. I think if we then look to the way that mediation is talked about in the case, I think the judge talks about it in much more positive terms. It is worth mentioning that the case didn't fully settle at mediation, although the mediation did narrow the issues in that the parents were able to accept some of the medical evidence that was put to them as part of that mediation process. So we see that the process of mediation is discussed by the judge in the judgment in terms of the mediation being imperative to reduce the levels of distress for this family. Also the fact that the parents were able to voice their concerns and participate in that mediation process, I think is presented in quite a stark contrast to the way that the clinical ethics committee process is discussed in the case. I think in many ways that's not necessarily surprising. You know, we know from the research that families very much value being involved in decision-making processes, and the Nuffield Council on Bioethics report on the causes of disagreements in the care of critically ill children, which I'm sure many of you here will be familiar with, you know, very much confirms this, you know, that parents want to be involved and value shared decision-making processes. Having said that, we also know that there has been some controversy around some of these comments, and particularly that, you know, clinical ethics committee processes and mediation processes can have quite different aims and kind of underpinning functions. But it is at least clear, I think, at this point that the courts think that both really need to show some way of involving families in both processes. So if trusts and healthcare professionals cannot show as part of litigation that they have involved families in those pre-court processes, then there is a risk that, you know, they might find themselves subject to some criticism, as in this particular case. Just briefly then, in terms of what might be required, the final point there on the slide, I've highlighted some comments from Mr. Justice Arbuthnot in the Verden case about how to involve families in clinical ethics committees. And there's also a really good article in the Journal of Medical Ethics last year about kind of how it kind of fleshes out in more detail about how that might be done. So both useful sources if you'd like to know more about that. Next slide, please. Thank you. What I also think is worth emphasising, though, is it's not just families and parents who are kind of emphasised as needing to be involved in decision-making. It's actually the patient themselves that the courts have emphasised should be involved as far as it's possible to do so. So I've mentioned here the Alderhay case. Briefly, the facts of this one were that it concerned a 14-year-old boy who was suffering from a range of medical conditions, which meant he'd been in hospital for over a year, I think, at the time of the proceedings. And the trust had made an application to extubate him and provide palliative care. Ultimately, the proceedings were adjourned for further expert evidence. The reason I mention this case now is I think it's a really interesting example of a very careful and detailed analysis within the judgment about seeking the patient's own views and wishes and feelings. So here we have a 14-year-old boy who was not Gillick competent. He was extremely unwell. He had very limited communication abilities. And yet in this judgment, the judge has a really careful and detailed analysis of whether and how to involve him in the case. Now, ultimately, she does decide that it's not appropriate for her to go and speak with the young person on the facts, but the really careful and close attention paid to the issue of participation of that young person, I think really shows how how much emphasis the courts are beginning to place on involving patients, families, and others in decision-making processes. Next slide, please. So that's an overview of the participation question and kind of involving patients and families in decision-making. I want to say a few words now before I hand over to Tor about the question of mediation and what the research says about mediation. So you might be involved in a case where you think you've done everything that you can to involve patients and families in the decision-making process, but really you think you might be heading to court to resolve that best interest dispute. Obviously, we know that many people have recommended mediation as an alternative to litigation, and there's kind of several reasons for that. The idea that bringing in an independent, neutral third party can be a more kind of flexible approach to resolving the dispute. It can have benefits for the working relationships of everyone involved, and allow people to be kind of understood and heard by each other better than litigation allows. The difficulty, though, is that there is relatively limited research evidence on the use of mediation kind of specific to this field. I wanted to highlight a couple of the sources of evidence that we have so far, and then provide some brief reflections on the research that I've been doing recently. So the Nuffield Council on Bioethics report, which I mentioned earlier, they obviously considered the use of mediation for disagreements in this area. They noted that none of the family members they'd spoken to had actually directly been involved in a mediation, but they did have some positive evidence from healthcare professionals about their experiences of mediation's use. And they've recommended further research into the use of mediation in this field. The first paper on the slide there by Nivjas looks at the use of mediation to avoid litigation in conflicts about medical treatment for children. Now, it's a really interesting paper, and she concludes that more than half of the cases would not have been preventable by mediation, either because no conflict existed or because the parental decision was based on strongly held, mostly faith-based views. So she acknowledges some role for mediation, but perhaps not as much of a role as others have suggested. So I think this is a really interesting perspective, that mediation might only be appropriate in certain types of conflict, so those where the parties are not deeply entrenched or where there aren't very strongly held religious beliefs at play. So as I mentioned earlier, I'm leading a research project at the moment which looks at the use of mediation in healthcare, and it's beginning to emerge. I mean, these are emerging findings, we are still collecting data, but it's beginning to emerge that there might need to be some more nuance in that. So in some of the interviews we've conducted with healthcare professionals, chaplains, family, and others, they think that even those strongly held views cases, those religious cases, might still be amenable to mediation if the mediation process can be set up in such a way to facilitate that frank and open discussion, and that all people might be open to difference or movement in their perspective if the mediation process can be set up in that way to encourage openness and collaboration. So the research on mediation is starting to emerge, showing some potential benefits of mediation in healthcare disputes, but still very much from the work that we're doing, something that we're still working on and collecting data on, and hopefully I can provide a further update on that in the coming year or so. I might mention a few words about the research project later if anyone would like to get involved, but otherwise that's everything from me, and I'll hand over to Tor.
Thanks, Amy. So I'm just going to look again at some of the cases and talk a bit about the court side of things. You've just heard from Jamie about, for example, the case of X in 2020, where the court was very enthusiastic about mediation, not just because in that case it meant that the parents had actually ended up agreeing with the treating doctors about certain things, but also just because the process itself was helpful for the parents to hear all the medical evidence and get really immersed in it. So that was a positive experience of it. Of course, for every positive comment, there's a judgment that you can find where someone says something different. And one of the other concerns that the courts have raised is the possibility of delay in a final decision being made if you pursue mediation. And so the case that's mentioned there of MB from 2019, that was a case involving an adult who didn't have capacity to make decisions for themselves. And the adult's family were completely opposed to the position of the treating clinicians. And they spent a very long time arguing about what should happen. And by the time the trust decided that they needed to go to court to have it resolved, a very long amount of time had passed, during which the person concerned had been subject to painful and uncomfortable treatment, which the court was going to find wasn't in their best interests. And so there is this permanent tension between trying to do things without going to court, trying to involve people, trying to give people a chance to reflect on things, change their position, obtain more evidence and review what they think the right answer is, and actually making sure that a decision is made if agreement can't be reached. And it's very difficult to know what the right approach and timescale is for all of that. And there is always a risk that if you head down the path of discussion and negotiation and then mediation, that by the time you eventually end up in court, if you can't resolve everything, someone will turn around and say, well, you should have come sooner. And that can be quite frustrating, because you've been doing everything you can to avoid being in court, and there was a realistic prospect that you wouldn't ever end up there. And it's only because things haven't quite worked out that you've had to apply. And then suddenly it's not only have you not managed to resolve everything, but now it's your fault for not having come to court sooner. Next slide, please, Sarah. Oh, thanks. So this is a quote from another case involving a child, and the court in that case noted that mediation had taken place over a period of 8 weeks, because, of course, although in other contexts sometimes mediation is capable of taking place over 1 or 2 days and everyone can set out their positions and a decision can be reached one way or the other. In a case about medical treatment, it may well be something where it's a much longer process. It may be something where one of the initial outcomes of mediation is that another second opinion is needed, or a third opinion, or a fourth opinion, or something of that sort. It may be that an outcome is that some form of further treatment or some other tests or other investigations should be carried out, and then everyone should get together again and see what that means. And so it isn't necessarily a sort of process that you can just set up mediation, have it on one day, and then that's it, and there's no sort of further involvement needed. But of course, if you then go down that path, time will go by, and if at the end of it you haven't actually reached agreement and you do need a court application, then you do need to be a bit careful about the overall timescales that you are bringing in. And as the court said here, ultimately, where what you're talking about is withholding treatment, where the medical view is that it's futile and burdensome, then you need to just keep your focus on the reality of the situation for the child and not let time slip away with you. Next slide, please. That's all very well, but isn't very useful in terms of actual concrete guidance from the court about what sort of timescales are and aren't appropriate. And one of the important things to bear in mind is that from the point at which a hospital decides we now need to make a court application to the court actually making a decision is actually quite a long period of time. Where there are incredibly urgent decisions to be made, such as whether a patient should receive a blood transfusion, the court deals with those very quickly. They can deal with them in an hour at a telephone hearing in the middle of the night. But where someone is in hospital, has been being treated for a period of time, and there's a dispute about the ongoing treatment, the court doesn't deal with cases in that incredibly speedy way. And the whole process does take actually quite a long time, because you have to first, as the hospital, let your solicitors know that you wish to make a court application. They then need to prepare all of the evidence that you're going to need to file with that application. And that is going to involve witness evidence from treating doctors, often in more than one specialism. It would usually involve evidence from nurses who've been involved in the patient's care. And it will involve getting all the medical records ready, getting all the other ancillary documentation that might exist from meetings or referrals or second opinions together. It might involve the solicitor saying, well, actually, before you apply to court, we should get a further second opinion before we even make that decision. So even once you have set the ball rolling in terms of going to court, it's going to be a period of weeks before an application can be issued. Once it is issued, the court is going to want to have an initial hearing, probably within a fairly short timescale of a week or two, in order to figure out what further evidence is required, to appoint a guardian for a child, to appoint the official solicitor for an adult, and also, importantly, to join family members to the proceedings and to give them an opportunity to obtain legal representation and potentially seek independent expert reports and so on. So all of that process, after an initial hearing, is also going to take a number of weeks. And then you have to wait for the court to have a gap in its diary in order to list a hearing in the event that there's still a disagreement. And the court may want to build into that timetable time for there to be a roundtable meeting after receipt of all the evidence, so that people have an opportunity to see whether they do still disagree about everything or not. So the hearing, the process from deciding to issue an application to the court making a decision is measured in weeks or possibly months. If there are then appeals of those decisions, it can go on even longer. And so you need to have that in mind when deciding the timing of whether you're going to go down the route of mediation and hold off applying to court, or whether you're going to do both at the same time, because even though you hope mediation will work, if it doesn't, you don't then want to build in further delay by not being ready to issue a court application. When cases do come to court, I think often there is a sort of just a real kind of clash of experiences and perspectives, because often the hospital is saying this patient has already been in intensive care for a number of weeks or months. It's very clear to us as the treating doctors that that treatment is not in the child's best interest or the adult's best interest, and yet we're still giving it to them. We've all come to the view that that's the wrong thing to be doing. And the longer that the child is in intensive care receiving this treatment, the worse it all is. Whereas the court, I think, comes to it and says, well, you are treating this patient, you have been for a number of months. If you have to carry on for another few months while the court gets all of its processes set up and the evidence is filed, then so be it. That's the way the system operates, and the court has to be able to make a proper decision, and everyone has to have a proper opportunity to put their evidence and have their position heard. And so there isn't the same quite the same perspective, I think, as there is from the point of view of a hospital, who have already probably been through a process over weeks or months of reaching their own conclusion about what should happen, and then expect that once they come to the court for a decision, that the court will act more quickly. The courts are obviously alive to the fact that the cases do need to be dealt with swiftly, but that is not at the expense of parents in particular and family members having a proper opportunity to obtain evidence. And if that means an independent expert report being obtained, then that's what that means. And if it takes 4 weeks to obtain it, then chances are the court will say, well, that's what we'll have to go with, because we can't constrain the parents' ability to obtain evidence which is necessary. So all of those factors have to sort of play into this question at the bottom: how should trust respond when a dispute arises? And I think really where they lead you to is that if you think there's a reasonable chance you may end up needing to make a court application as a trust, then you need to start thinking about that sooner rather than later, even if at the same time you are following other routes such as mediation in order to try and avoid actually ending up with the court process. Otherwise, if you do everything sequentially, it will take a long time. And that, I think, itself can pose problems for everyone, but including for the trusts, because when the proceedings then actually start, they are anxious about how slowly everything is going and how much time the court is affording people to respond to evidence and so on. And that just adds to the sort of difficult tension that there is in a court process, because the trust is then urging the court to list hearings urgently, and the parents are urging the court to give them enough time. And it just becomes another thing to argue about, which adds to the sort of the general feeling on the part of parents that the trusts are just trying to rush this incredibly important decision through the court, and on the part of trusts that parents are deliberately trying to delay the decision. And so it does make everything worse. The other reference that's on that page is to the Court of Appeal, making negative comments about delay. So the courts, as I say, the courts are alive to the fact that things do need to be dealt with as swiftly as possible, but they are, in my experience, often that is not as swiftly as a hospital trust things ought to be dealt with. And so that suggests to me that decisions about applying to court probably need to happen sooner rather than later. And that may mean that a trust ends up asking its solicitors to prepare witness evidence, which turns out not to be needed because you don't need to go to court because everyone has actually reached an agreement. But at least you were prepared for that, and the extra delay from the court application was something that you would have been able to avoid had that mediation not been successful. One of the other points that I wanted to just touch on was the adversarial nature of the court process, and the possibility that had been raised of whether or not there was some way of rearranging the way these court processes work so that people are, families and hospital trusts are approaching the court together to ask for resolution of a difficult question, rather than the framing being a trust taking parents to court. Procedurally, the court needs there to be an applicant. There can be joint applicants, but only if those joint applicants are both seeking the same order. So if a trust and a family are in dispute about what order should be made, they can't both be the joint applicant to some proceedings. Having said that, there are things which a trust could do to promote the feeling and experience of the court process as being a more collaborative one. And so that would include things like letting the family know at a very early stage, we're going to make an application to the court. We're also going to go down the mediation path, but we need to do both because we can't afford the delay that would be involved of doing them sequentially. We're going to make the application, and we're going to say to the court, this is what we think the right answer is, and here's all our evidence. And we'll say this is what the parents think, and this is, the evidence that they would like to have. But we will make sure that we share our evidence with you as soon as it's ready to be filed at the court, so that you have as long as possible to look at it. We'll help you locate solicitors who might be able to represent you. We'll make sure that you have adequate time to instruct them and to consider everything before any hearings take place, so that you don't feel that you're being rushed into things. And so there are sort of procedural things that probably the trust legal teams can do to try and make the process slightly less hostile to parents. Sarah, can you just go on to the next slide so I can remember whether it's mine or Jamie's? Yeah. So I am going to probably draw my bit to an end there and pass back to Jamie to talk a little bit about the research. I can see various questions popping up in the chat, and it'd be good to leave as much time as we can for questions and answers. So I will pause there and hand back to Jamie.
Thanks very much, Tor. Sarah, next slide, please. Yeah, so as I mentioned earlier, just to reiterate briefly that I'm leading a project that is trying to gather some more evidence about mediation's use in healthcare disputes. So we're currently still doing research interviews with a range of people, so healthcare professionals, mediators, family members, anyone who has been involved in a mediation and would like to share their experiences with us. We're still doing the research for another couple of months, so please do get in touch if you're interested in taking part. But otherwise, thank you very much for listening. And yeah, happy to take any questions.